Good morning. This is the time and place for the planning hearing officer hearing of, what are we? September 19th, 2012. My name is Roger Kiesel, and I will be conducting the hearing as hearing officer. We have one case today, and relevant exhibits are posted on the panels located directly behind me. There is one variance case on the agenda this morning. Under the provisions of Title 30, Chapter 30.43 of the Glendale Municipal Code, a variance shall be granted if four required findings are present. The first finding is that the strict application of the ordinance would result in practical difficulties or unnecessary hardship, inconsistent with the general purposes and intent of the ordinance. The second finding is that there are exceptional circumstances or conditions applicable to the property involved or to the intended use or development of the property that do not generally apply to other property in the same zone or neighborhood. The third finding is that the granting of the variance will not be materially detrimental to the public welfare or injurious to the property or improvements in such zone or neighborhood in which the property is located. And then finally, that the granting of the variance will not be contrary to the objectives of the ordinance. Findings. If the evidence presented in the application at the public hearing meets the criteria just described, then the hearing officer can either approve or impose conditions for approval on the case in question. If the findings of fact are not evident, then the request is denied. Public notice. Notifications of the hearing were accomplished by the use of public notices, which were mailed to property owners and occupants located within 500 feet of the subject property, physically posted on the site, and placed in the local newspaper. The hearing will proceed as follows. I'll read the description of the application request. I'll read the reports received from other city departments and other letters or communications from interested parties. The case planner will then make a brief overview of the case, give analysis, and make a recommendation. The applicant will then be asked to come forward stating both name and address, and will be asked to present a case within a 15-minute time period. Others in support of or in opposition to the application and interested parties will be asked to come forward to speak, clearly stating both name and address within a 3-minute time limit. Lastly, the applicant will be given the opportunity to make closing comments, if desired, in response to testimonies given by the preceding speakers within a 5-minute time limit. And then finally, the hearing will be closed and the case taken under submission. Decision. After the hearing, the decision will be prepared in writing and will be in the form of a letter sent to the applicant and to all persons who responded to the public notice, either by speaking at this hearing or by submitting written responses and have provided their names and mailing addresses. The date of the decision will be the date appearing on the letter. Appeals. Under the appeal provisions of Title 30, Chapter 30.62, the Glendale Municipal Code, the decision may be appealed to the Planning Commission within 15 days of the date of the decision. Anyone wishing to appeal may obtain forms and brochures on the procedures from the Building and Safety Section Permit Services Center, located on the same floor of this building. Speaker's cards. If you wish to speak, please write your name and address on one of the speaker's forms, which have been provided by the table or by the front door, and submit it to our assistant. The official proceedings of the planning hearing officer's hearing are recorded on tape as part of the public record. We'll go on to our only case. As I mentioned before, it's the application for a standards variance. The location is at 3154 Charing Cross Place. It's standard variance case number PVAR 1219554. The applicant is Mike Garagos. The property owner is Aram Ohanis. The case planner is Rather Duong, and the request is an application for a standards variance to maintain an existing legal non-conforming interior setback of 4 feet in conjunction with a new second-story addition, which increases the overall height of the residence to 23 feet 6 inches. The minimum required interior setback is 5 feet for a residence between 20 feet and 30 feet in height. Again, the residence is located at 3154 Charing Cross Place in the R1R-2 district, described as Lot 17, Block 1, Track number 9327. Let me first go over comments from other city departments, and then we'll have Rather speak. Okay, from GWP Electric, basically just standard conditions comments. Urban Forestry, they had a comment. Plans provided declare no bay or sycamore on site or within 20 feet. However, site observation done from the public right-of-way indicates some oak trees may be within 20 feet of the property line. This project appears supportable by forestry section. However, plans do not reflect all the indigenous trees with accurate drip lines. Also, the scope of the work and project description on the plans does not match. Please provide corrections and resubmit for further review and comment. Integrated Waste did not have any comments. Parks stated that the project is subject to the Public Use Facilities Development Impact Fee Ordinance for parks, recreation, libraries. Building and Safety had standard conditions. Traffic did not have any comments. Fire, engineering, had standard comments. And that was it. All right, so I'd like to ask Rather Duong to make a presentation on the case. Thank you.
Good morning. Thank you. Hearing Officer Kiesel. The project before you, standards variant case number PVAR 1219554, located at 3154 Charing Cross Place, which is zone R1R, floor area Racial District 2, and located within the Chevy Chase neighborhood. The applicant, as you stated earlier, is requesting to maintain the existing 4-foot legal non-conforming interior setback along both the east and west sides of the property. This is in conjunction with a proposal to construct a new second-story addition totaling 1,001 square feet to an existing single-family house that is currently 1-story and features 1,372 square feet of livable space. According to the zoning code, a resident with an overall height of more than 20 feet and up to 30 feet high is required to provide an interior setback of 5 feet. The new height of the house with the proposed addition will be 23 feet 6 inches. The project site is a relatively flat 5,954 square foot lot that is irregular in shape. The lot was developed in 1961 with a 1-story house and an attached 2-car garage in the ranch style. The existing residence, as I stated, is 1,372 square feet, and there is a swimming pool and a combination of an on-grade and raised deck located at the rear of the lot. The majority of the lot is flat but has a slight downward slope at the rear. The subject property is located in a residentially zoned neighborhood consisting of both 1- and 2-story homes on a short cul-de-sac street. The homes on the streets were constructed between the 1930s through the 1960s and showcase various architectural styles. The existing residence is centrally located in the middle of the lot and originally was developed with a 4-foot interior setback. In the rear yard, there is again a pool and a deck. The proposed addition will not change the existing building footprint or landscape ratio since it will be located entirely on the second floor above the existing house. Therefore, there will be no grading proposed, and as such, no changes to the existing landform. The existing house is modest in size, but with the proposed addition, it will bring the total size of the house to 2,373 square feet. A number of alternatives exist for some type of expansion on this property. However, each option has its challenges as it relates to the zoning code and or site planning of the property. Demolishing 1 foot of the existing house on the east and west elevations would increase the interior setback from 4 to 5 feet. But in this scenario, the garage will be made smaller to a size that is below the minimum that would be in compliance with the zoning code. Further, there would be extensive interior remodel. Removing 1 foot from each wall for the entire length will affect the legal non-conforming status of the residence, as demolition will likely exceed 50% of the exterior wall and roof area, and the project would be deemed brand new construction. A second alternative is to construct a 1-story addition to the rear of the existing house. However, as previously mentioned, the rear is improved with a large deck and a swimming pool. This option would also eliminate much of the usable outdoor space. But more importantly, any first-floor addition on this property will increase the lot coverage ratio to above the permitted 40% maximum, and would also create an appearance of an overbuilt property. This will negatively affect the site planning of the property and will make it more inconsistent with the neighboring properties. The existing lot coverage is essentially at 40%, 39.9%. Any ground floor addition will require another variance for exceeding the lot coverage. A third alternative is to add to the front of the existing house. This option would affect the rhythm of the streetscape since the house will be closer to the street and impact the relatively uniform street front setback on the street. This option would also exceed the maximum allowable lot coverage. As such, a new second floor addition, while retaining existing interior setback, appears to be the most sensible option since the new second floor will be stepped 11 feet from the west elevation and 7 feet along the east elevation. These distances will help mitigate concerns relating to mass and scale and help eliminate the perceived effect of a taller building peering over its neighbor. Based on the facts surrounding this variance request, staff recommends approval of the project with some specific condition as well as the standards condition that are typically attached to this type of request. And staff did not receive any correspondences, whether it be email, phone calls, or letters concerning this item. Thank you.
Thanks. Yeah, thanks for mentioning that. I forgot to ask that. All right, we have one speaker card. The applicant, Mike Garagos.
Good morning. Mike Garagos, 3501 Buena Vista, Glendale. Thank you very much, for all your help on this. We're in agreement with the staff report. It acknowledges the fact that there's very few options for expanding this house in a way that would be sensitive to the zoning code and intent. What we're proposing an addition that increases side yard setbacks on the second floor, so we'd be minimizing what would normally be allowed at 5 feet, so we're going to 7 and actually 10 foot 10. There's no change to existing first floor setbacks, so any current conditions would be maintained. So we are in agreement with the staff report, and I would just want to discuss the one issue on the recommendations, number 2, which is width of the driveway reduced to the width of the garage door opening.
Okay, actually, that's going to be a question I am going to ask. Can you briefly go over the findings?
Sure. Sorry. The idea being that any other strict application would be impractical with difficulties, unnecessary hardship. As Rather mentioned, there's really not a lot of other options in order to expand this property, and the way we are proposing it is consistent with the zoning code and the intent. The strict application would require considerable modifications to the existing house and would be an unreasonable hardship. Second one of the exceptional circumstances is the fact that we have those existing placements of the existing house. There is no change to those, so any current conditions would be maintained. So the exceptional circumstances is the existing placement of the house. In terms of granting the variance will not materially detrimental to public welfare, what we're doing is proposing a second floor that is allowed or considerably under the maximum height for a second floor. There's nothing about the second floor that requires any special discretionary review. It's all compliant. We're actually increasing side yard. So there's nothing about the granting of this variance that would be detrimental to the public welfare. Along that line, I would want to say that there are 2 additional houses within the immediate proximity that actually have substandard setbacks for their 2-story extension. There's one that's across the street and one over. That is a 2-story that maintains a sheer face at the 4-foot line for 2 stories. So they actually have existing conditions that are more onerous than what we're proposing. Granting a variance will not contradict the objective of the ordinance. The intent of the ordinance is light and ventilation and openness between buildings. By increasing the second floor setback beyond what's required, we believe we're addressing that issue, and we're proposing something that isn't even asking for what the code is. We're actually expanding what is required by code. So we're in agreement with staff's analysis of those 4
Staff's
findings.
recommending approval, so.
We like that. That's a good
That would
thing.
surprise me if you're not. All right, you were going to,
I'd like to address number 2 on the recommendations.
yeah, and that was going to be a question. Let me just read the recommended staff condition, that the width of the driveway shall be reduced to the width of the driveway opening. New landscaping shall be planted along the modified driveway.
I think in this particular situation, as is the case with many hillside homes, there's not a lot of opportunity for an essentially paved area or parking. And I think if you had anybody, temporarily parking in the driveway, trying to get out, if there happen to be temporarily garbage cans or anything else, there is a small planter that's 2 foot wide beside the driveway now that we could maintain, and we could condition that through design review that it would be embellished.
That go all the way up to the
Right.
property line?
Yeah, if we could, on the street view, if there's any way of swinging that to the right, just taking our view, there you go. You can see that we have that strip starts out kind of on the width of the garage opening and then gets wider, right. So there is a portion that's going there, and like I said, we can condition that to be embellished through design review. I think because of the tight opening, I think it's unreasonable to, minimize that just for maneuvering in and out of a car. But as I mentioned, I think it would be, the owner would be supportive of reviewing that through design review, that it would have some kind of updating to that landscaping.
Okay. How about, what's going on in this area?
That's just a backyard maneuvering and whatnot, storage and, regular, they have 2 children, and there's, associated playing equipment and whatnot. There is quite a bit of openness at the back. The deck doesn't go to the side. There's a setback on the side of the deck. So I think there's very much an openness there. There is no special windows out of the adjacent house. There's a wood fence along that side. And I think, again, I think it would be unnecessary to plant in that area because there would be no benefit to anybody, and it would be a negative to the use for the owner.
That would be along the west
Yes.
west elevation,
West
right?
elevation, yes.
So
And it's on that side.
Yes.
Yeah, down below the lower floor plan.
right, but I'm talking about the windows up here.
Right.
Here.
Right. Yeah, they're high. Those are just high windows out. I'm saying from the adjacent property. The adjacent property doesn't have. No one would benefit by landscaping in that section beside the house, and there is a wood fence there now, and the adjacent house is not really viewing from that area, and I think it just minimizes their opportunity on a hillside lot to have just general use of a paved area. So I would respectively wish that not to be a requirement.
So you're not totally in agreement.
Well, like I said, I can understand updating the planter beside the driveway. I just would hope that we wouldn't have to expand the planting area.
Okay. Both you and Rather have gone through some of the alternatives. It might be helpful to just, if you can come up and just go over, okay, this is what we're doing, but here's why we can't do this, this, and this. Right there.
The lighter brown is the existing house perimeter with garage. The existing house has those tight setbacks. It's actually slightly larger here because of the shape of the lot. So, as Rather mentioned, there's not a lot of opportunity. Obviously, you couldn't open to the side. Any opening to the rear would encroach on existing work that's happening at the pool. There's a nice variation to the front facade in terms of how that works. So that, again, that would be unfortunate to be pushing out to the front. And there really isn't a lot of space even to add out in that area, footage-wise. In addition to the fact that we already limited on the lot coverage. So what we decided to do was to add the second floor, but again, we're increasing the side yard setbacks so that the impact of this would be considerably less than if we had the 5-foot and we had stacked it at the 5-foot line. We're actually proposing something that would be less onerous than what would be allowed by current code. So if I have answered your question.
Oh, okay. I see that. Because the second floor could be 5 feet.
The second floor could be 5 feet, which
That-
means we could have it would be closer on this side, and we could be filling in this whole section here to 5 feet. So
Right. Okay.
its impact on the neighbor would be more than what we're proposing.
Got it. All right. And then my final question is with regard to the comment from Urban Forestry. It looks like, according to them, there are some protected trees maybe adjacent to the site, not on the site.
As I'm thinking about it, and you see in that view, there might be one on the property on the right-hand side at the back that might be an oak. That one right there might be.
Oh. Okay.
But we're adding completely over the existing house, and there's no drip line that we would be encumbering. The trees at the back are pines, and we're considerably outside of those drip lines. So you can see that there's no canopy that we're encroaching into, and we're adding directly on top of the house, so we wouldn't be discharging load onto existing trees.
But there aren't protected trees on the site. There may be adjacent.
Yes.
Okay. But regardless, it sounds like the urban forester has gone out and said, even though there appears to be something, what you're proposing to do is okay.
Right.
Okay. All right. Okay. Those were all the questions I had. Do you have anything else to add?
No. The applicant has 2 children. They're hoping to stay in the area, and this addition would make the property much more livable for them, and hoping for your concordance.
Okay, great.
Thank you.
Thanks. I'll close the public hearing. The hearing is now officially closed. Thank you for coming. And it is 10 o'clock. Thanks.